Hello, good evening to all of you. I hope all of you are doing great. तो चलिए आज के डिस्कशन को शुरू करते हैं. So today we are going to discuss the trial procedure of the code provided under CrPC, right? So the first question for the day is Court of Sessions under Section 199 of CrPC has the original jurisdiction to take cognizance on an oral complaint of a private person, option B, on an oral complaint of public prosecutor, option C, on a written complaint of a private person, and option D, on the written complaint of a public prosecutor. So what should be the correct answer for this? Hanji. The question is, the Court of Session under Section 199 of CrPC has the power to take cognizance as original jurisdiction on oral complaint of a private person, on written complaint of a private person, on oral complaint of a private person, option A, option B, on the oral complaint of public prosecutor, option C, on the written complaint of a private person, option D, on a written complaint of a public prosecutor. What should be the correct answer? क्या होगा इसका correct answer? जल्दी से बताइए. हाँ जी. What should be the correct answer of this question? Its correct answer will be on the written complaint of a private person. So whenever a private person is making a written complaint, okay, just a second. No, its correct answer will be on the oral complaint of public prosecutor. चलिए आगे बढ़ते हैं नेक्स्ट क्वेश्चन पे. क्वेश्चन नंबर 2. द पीरियड ऑफ लिमिटेशन प्रिस्क्राइब्ड for making a complaint to the court of session in original jurisdiction is 3 months from the date of commission of offence, 6 months from the date of commission of offence, 1 year from the date of commission of offence, and option D as provided under section 468 of CrPC. What should be the correct answer? Correct answer is yep. What should be the correct answer? Correct answer is 6 months from the date of commission of offence. Next question पे चलते हैं. Question number 3. Under section 188 of CrPC, under section 180 of CrPC, the sanction of central government is option A, condition precedent for taking cognizance of the offence, not a condition precedent for taking cognizance and could be obtained from trial begins. C, not necessary. Option D, necessary only where a foreigner is involved in the commission of the offence. What should be the correct answer? बताइए क्या होगा इसका करेक्ट आंसर? हाँ जी. तो जल्दी से बताइए. आई एम वेटिंग फॉर यू. Its correct answer shall be option B, not a condition precedent for taking cognizance and could be obtained before the trial begins. Now moving towards next question. Taking cognizance is a judicial function, an administrative function, a supervisory function, both A and B. taking cognizance of an offense is a judicial function, an administrative function, a supervisory function, both A and B? What should be the correct answer? So it is a judicial function. Its correct answer will be, it is a judicial function. So A is the correct answer. While taking cognizance, the court takes cognizance of the offense, the offender if there are more than one, and all of the above. What should be the correct answer? While taking cognizance, the court takes cognizance of the offense, the offenders if there are more than one, and all of the above. What should be the correct answer? The court takes cognizance of what thing? बताइए जल्दी से कमेंट सेक्शन में. कोर्ट किस चीज का कॉग्निजेंस लेता है? ऑफेंस का, ऑफेंडर का, द ऑफेंडर इफ देयर आर मोर देन वन, एंड ऑल ऑफ द अबव. व्हाट शुड बी द करेक्ट आंसर? अब ये चीज वेल सेटल्ड है दैट द कोर्ट ऑलवेज टेक्स कॉग्निजेंस ऑफ व्हाट? कोर्ट टेक्स कॉग्निजेंस ऑफ द ऑफेंस. सो इट्स करेक्ट आंसर शैल बी द ऑफेंस. Next, the court is said to have taken cognizance when orders investigation under section 156 clause 3 of CrPC, issues a search warrant for the purpose of investigation, both A and B, neither A nor B. What should be the correct answer? कब बोल सकते हैं that the court has taken cognizance of a particular offense? जब कोर्ट इन्वेस्टिगेशन ऑर्डर कर दे, जब कोर्ट सर्च वारंट इशू कर दे, both A and B, neither A nor B. It is only considered that the court has taken cognizance when the charges are framed under section 211 of CrPC. So its correct answer shall be option D. Question number 7. The competency and jurisdiction of magistrate to take cognizance of the offence affected by the illegality committed in the course of investigation, affected by the irregularity committed in the course of investigation, neither A nor B. Option D, both A and B. The competency and jurisdiction of the magistrate to take cognizance of the offence affected by the illegality committed in the course of investigation, affected by the irregularity committed in the course of investigation. Option C, neither A nor B. Option D, both A and B. What should be the correct answer? So its correct answer shall be neither A nor B. Because if we are talking about the power of the magistrate to take cognizance, so if a magistrate is taking cognizance whether he has done something illegal or irregular, ठीक है, it shall not affect the taking cognizance of the case. Reason behind, because अगर आप यहाँ पे देखेंगे तो here you will find the word investigation. ठीक है, investigation and investigation, and investigation is never ever done by the court, so it is impossible to have these things over here. So its correct answer shall be option C, because all of us are aware that the court does not do the investigation. The magistrate never do the investigation. Rather than the investigation is done by the police officer or any other person appointed by the court on that behalf. Next question, question number 8. At the time of taking cognizance, the magistrate is to see whether there are sufficient grounds on record to proceed against the accused person, whether there next option is whether there is a prima facie case against the accused person to frame the charges. Option C, shift or appreciate the evidence with reference to the material and come to the conclusion whether prima facie case is made out against the accused. Option D, all of the above. What should be the correct answer? At the time of taking cognizance, the magistrate is to see whether there are sufficient grounds to proceed against the accused or not. If the court sees there are sufficient ground to proceed against the accused, then the court can take or the magistrate can take cognizance. So its correct answer shall be option A. Next, where the magistrate take cognizance suo motu under section 191C of CrPC, the compliance of provision of section 191 of CrPC is directory, being procedural, mandatory, discretionary and optional. Question number 9, what should be the correct answer? जब मैजिस्ट्रेट अंडर सेक्शन 190 सब clause 1C takes cognizance of an offense, then in that case what will happen? The magistrate has to create the compliance with the provision, doesn't have to compliance with the provision since it's directory, and discretionary. What should be the correct answer? And the last option is optional. I hope it's clear to all of you. You are not getting any confusion in it. Where the magistrate takes cognizance suo motu under section 191C of CrPC, the compliance with the provision of section 191 of CrPC is directory, being procedural, mandatory, discretionary and optional. What should be the correct answer? So its correct answer is mandatory. So option B is the correct answer. Next question. Non-compliance with the provision of section 191 of CrPC, where cognizance is taken by the magistrate under section 191C of CrPC, vitiate the trial and the proceeding will be wholly void. ठीक है? It is an irregularity curable under section 460 of CrPC, does not vitiate the trial unless it is caused prejudice to the accused. He amounts to waiver of his right by the accused. What should be the correct answer? Question number 10. क्या होगा correct answer? It's question number 10. Its correct answer will be vitiate the trial and the proceeding shall be wholly void. And now this thing you can read under section 461 of CrPC, which is stating about the cases where the complete proceeding is void. So its correct answer shall be A. Next question, under section 190 of CrPC provides for taking cognizance by the magistrate on the police report filed under section 173 of CrPC, on the complaint within the meaning of section 2D of CrPC, suo motu, all of the above. Which of the following provision empowers the magistrate to take cognizance of an offense? On the police report filed under section 173 of CrPC, on the complaint within the meaning of section 2D of CrPC, suo motu and all of the above. अब यहाँ पे समझने वाली बात क्या है? That whenever police report is filed under section 173 of CrPC, that shall be governed under section 191A. 191B talks about where the magistrate orders or gets the information for the conduction of investigation. And the last one is 190 clause 1C, that is suo motu, like by his own discretion he orders the police to investigate a case. So all of these three powers are given to the magistrate under section 190. So its correct answer shall be option D. चलिए अगले क्वेश्चन पे बढ़ते हैं. On the receipt of complaint within the meaning of section 2D of CrPC, the magistrate has the jurisdiction to conduct an inquiry by himself, has jurisdiction to direct the police to investigate. Option C, both A and B. Option D, only B, not A. What should be the correct answer? When the magistrate receives a complaint under section 2D of CrPC, the magistrate has the power or has the jurisdiction to conduct an inquiry by himself, to direct the police to investigate the matter. Both A and B, and only B, not A. So its correct answer shall be option C. नेक्स्ट क्वेश्चन पे चलते हैं. Cognizance of offense punishable under chapter 10 of IPC can be taken by the magistrate on the police report on the written complaint of public servant, both A and B, only A and not B. What should be the correct answer? Question number 13. So chapter 10 है, that is chapter 10 of IPC, that is talking about the cases of defamation. So if there is a defamation done by, of a public servant, such cases can be dealt only by the written complaint of such public servant. The provision of section 195 of CrPC are directory being procedural, discretionary depending upon the facts and circumstances of the case. Option C optional for the court and option D mandatory. What should be the correct answer? Question number 14. The provision of section 195 of CrPC are discretionary, directory, optional for the court and mandatory. What should be the correct answer? Its correct answer is mandatory. Next, the provision of section 195 of CrPC requires a complaint in writing, an oral complaint, either A or B, neither A nor B. The provisions of section 195 of CrPC requires a complaint in writing, an oral complaint, either A or B, neither A nor B. What should be the correct answer? So that requires a complaint in writing. Under section 195 of CrPC, it requires complaint in writing. Next, under section 195 of CrPC, the complaint in writing must be option A, the public servant concerned, option B, an officer to whom such public servant is administratively subordinate, option C, either A or B, option D, both A and B. What should be the correct answer? So either the public servant himself can do the same, or any of the administrative person who is superior to him, to whom he is subordinate, can do the same. He can make a written complaint to the magistrate to conduct the to take cognizance of the case. So its correct answer shall be option C, either A or B. Question number 70. Section 195 to section 199 of CrPC lays down rules of procedure simply without creating any bar to the taking of cognizance by a court. Create a bar to taking of cognizance unless some requirements are complied with. Option C, create an absolute bar to the taking of cognizance irrespective of whether the requirements are complied with or not. Option D, either A or C. What should be the correct answer? Section 195 to 199 of CrPC lays down rule of procedure without creating any bar. Create a bar for taking cognizance unless some requirements are not complied with. Create an absolute bar to taking cognizance irrespective of whether the requirements are complied of or not. Option D, either A or C. What should be the correct answer? Its correct answer is create a bar on taking cognizance unless some requirements are complied. Next, question number 18. Under section 195 of CrPC, a complaint can be filed by a public servant, a private individual, police, either A or B or C. Under section 195 of CrPC, a complaint can be filed by a public servant, a private individual, police, either A or B or C. So its correct answer shall be a public servant. Under section 197 of CrPC, affords protection to private individual, employees of the public sector undertaking, public servants, all of the above. Section 197 provides the protection to private individual, employees of public sector undertaking, PSUs, public servants, and option D, all of the above. What should be the correct answer? So it provides the protection only to the public servant, not to the member of public sector units or public sector undertakings. Neither it provides any kind of protection to private individuals. So its correct answer shall be option C. Question number 20. Prosecution for offence against marriage under chapter 20 of IPC can be launched by any person through a complaint, can be launched by any person aggrieved by the offence through a complaint, can be launched by a police officer, D, all of the above. ठीक है, offences relating to marriage, by which way the prosecution can be started. जब हस्बैंड या वाइफ कंप्लेन करे कि मेरे अगेंस्ट कुछ गलत हुआ है, या फिर हस्बैंड या वाइफ और उनके रिलेटिव कंप्लेन करें, या फिर पुलिस कंप्लेन करे, या फिर ऑप्शन डी इज ऑल ऑफ द अबव. व्हाट शुड बी द करेक्ट आंसर? So either the aggrieved person, that means either the husband or the wife or any of the relative lodges the complaint, then only in that case the case can be initiated against them. Next, cognizance of offense under section 498A of IPC can be taken on police report. Option B, on the complaint of the aggrieved person. Option C, on the complaint of father, mother, brother or sister of the person aggrieved. Option D, all of the above. 498A, डोमेस्टिक वायलेंस, घरेलू मारपीट का अगर कोई केस है तो वो कैसे कोर्ट कॉग्निजेंस ले सकता है? मैजिस्ट्रेट साहब कैसे संज्ञान लेंगे उस मैटर में? पुलिस रिपोर्ट पे, या फिर अग्रीव पर्सन की कंप्लेंट पे, या फिर फादर, मदर, ब्रदर, सिस्टर जो अग्रीव पर्सन है उनकी कंप्लेंट पे, या फिर ऑल ऑफ दी अबव? अगर घरेलू मारपीट का केस है, डोमेस्टिक वायलेंस का केस है अंडर सेक्शन 498A ऑफ आईपीसी, then the magistrate can take cognizance of such offense on the police report, on the complaint of aggrieved person, on the complaint of the relative of the aggrieved person, which includes father, mother, brother, sister of the aggrieved person, and all of the above. Which correct answer shall be option D, that is all of the above. Next, question number 22. Cognizance of offense of defamation under chapter 21 of IPC can be taken on the police report, on the complaint made by an aggrieved person, suo motu, and all of the above. अगर defamation का कोई case है under chapter 21 of IPC, then the cognizance of such case can be taken by the police report, by the complaint made by the aggrieved person, by suo motu. Suo motu means the court can take the cognizance by his own. That is called swatah sangyan. And option D, all of the above. What should be the correct answer? When the complaint is made by the aggrieved person, the person against whom such defamatory statement has lodged. Next, question number 23. Where the magistrate takes cognizance of the offense on the complaint made to him and the considers before the issue of process to the accused that the matter should be investigated, such investigation can be ordered under section 156 clause 3 of CRPC, section 190 of CRPC, under section 173 clause 8 of CRPC, under section 202 of CRPC. When the magistrate takes cognizance of an offense on complaint made to him and considers before the issue of process that the accused should be investigated. accused का investigation चाहते हैं magistrate साहब, accused की complaint पे संज्ञान लेने से पहले, cognizance लेने से पहले, तो वो कौन से section के अंदर investigation order कर सकते हैं? 156 clause 3, 190, 173 clause 8 and section 202 of CRPC. What should be the correct answer? So magistrate can issue the investigation under section 202 of CRPC. So its correct answer shall be option D. Next question, question number 24. On the receipt of a complaint before the ordering investigation by the police under section 156 clause 3 of CRPC, the magistrate has to see that the complainant has disclosed cognizable offences triable by magistrate. The complainant has disclosed cognizable offences exclusively triable by court of session. The complainant discloses cognizable offences irrespective of whether the same are triable by magistrate or exclusively by court of session. Option D, the complainant discloses cognizable offences only triable by the magistrate and not exclusively triable by the court of session, as it is for the magistrate to inquire himself into the offence exclusively triable by the court of session. What should be the correct answer? क्या होगा इसका करेक्ट आंसर बताइए? So when the magistrate notices that there is a case that there are some cognizable offences committed, and against those cognizable offences the complaint has been made, then the magistrate has to take cognizance without looking into the matter whether they are triable by court of session exclusively or by him exclusively. So its correct answer shall be option C. अगले क्वेश्चन पे बढ़ते हैं. In complaint disclosing commission of offence triable by magistrate, option A, it is necessary to examine the complainant and all the other witnesses on oath. Option B, it is not necessary to examine the complainant and all other witnesses on oath. Option C, it is necessary to examine complainant on oath and it is not necessary to examine all other witnesses. Option D, both A and C. What should be the correct answer? अगर मैजिस्ट्रेट साहब को ये लग रहा है कंप्लेंट में कि यहाँ पे ऑफेंस हुआ है तो क्या होगा? इज इट नेसेसरी टू एग्जामिन द कंप्लेंट? इट इज नॉट नेसेसरी टू एग्जामिन द कंप्लेंट. It is necessary to examine the complainant on oath and it is not necessary to examine all other witnesses, and option D is both A and C. Its correct answer shall be option B. Next question. Recording of pre-summoning evidence may be dispensed under section 200 of CrPC if the complaint is supported by the affidavit of the complainant, if the complaint is made in writing by a public servant in the discharge of his official duty. Option C, both A and B, and option D, only A is correct but B is incorrect. Recording of pre-summoning evidence may be dispensed with under section 200 of CrPC if the complaint is made in writing by public servant discharging his official duty. So its correct answer shall be option B. Next, once the magistrate has proceeded with examination of the complainant or decided to record the statement of the complainant on oath, the police cannot be directed to investigate under section 156 clause 3 of CrPC. The police can be directed to investigate under section 156 clause 3 of CrPC. The police may or may not be directed to investigate under section 156 clause 3 of CrPC depending on the various facts and circumstances. And option D, both B and C. What should be the correct answer? अगर मैजिस्ट्रेट साहब ने एग्जामिनेशन कर लिया है कंप्लेनेंट का एंड डिसाइडेड टू रिकॉर्ड द स्टेटमेंट ऑफ कंप्लेनेंट ऑन ओथ, देन द पुलिस कैन नॉट बी डायरेक्टेड टू इन्वेस्टिगेट द मैटर अंडर सेक्शन 156 क्लॉज 3 ऑफ सीआरपीसी, क्योंकि मैजिस्ट्रेट साहब ने डायरेक्टली स्टेटमेंट रिकॉर्ड कर लिया है. और जब मैजिस्ट्रेट साहब ने एक बार डायरेक्टली स्टेटमेंट रिकॉर्ड कर लिया है तो इट इज वेरी मच सिंपल दैट नो इन्वेस्टिगेशन इज रिक्वायर्ड इन दैट पर्टिकुलर केस. नेक्स्ट क्वेश्चन. On complaint for offences triable by magistrate after the recording of statement of the complainant and the witness, if any, on oath, the police can be directed to investigate under section 156 clause 3 of CrPC. The police can be directed to investigate under section 202 of CrPC. Option C, both A and B. Option D, neither A nor B. What should be the correct answer? Then the magistrate can order the investigation of the police under section 202 of CrPC. Next, on the complaint of offences triable by the court of session after recording the statement of the complainant and the witness on oath, the police can be directed to investigate under section 156 clause 3 of CrPC. The police can be directed to investigate under section 202 of CrPC. The police cannot be directed to investigate at all and the magistrate himself has to conduct the inquiry. Option D, both A and B. What should be the correct answer? अगर कोर्ट ऑफ सेशन में कोई कंप्लेन, कोई भी केस ऐसा है जो कि ट्राइबल है बाय एक्सक्लूसिवली बाय कोर्ट ऑफ सेशन एंड द कंप्लेनेंट स्टेटमेंट हैज बीन रिकॉर्डेड, ठीक है, देन इन दैट केस the witnesses on oath have to be followed up by which process? So here the magistrate himself can conduct the inquiry. Direction to the police to investigate under section 202 of CrPC can be given without examining the complainant on oath, cannot be given without examining complainant on oath, can be given before or after examining complainant on oath. Option D, both A and C. What should be the correct answer? Direction of the police to investigate in the matter under section 202 of CrPC can be given without examining the complainant on oath, cannot be given without examining complainant on oath, can be given before or after examining complainant on oath, both A and C. In a complaint disclosing commission of offences exclusively triable by the Court of Session, option A, it is necessary that the complainant and some of the witnesses be examined on oath. It is necessary to examine the complainant on oath and no witness need to be examined on oath. It is necessary to examine the complainant and all of the witnesses on oath, and option D, either A or B. What should be the correct answer? It is necessary to examine complainant and all the witnesses on oath. Next, filing the list of witnesses by the complainant before issuance of summon or warrant to the accused under section 204 of CrPC is mandatory, is directory, neither mandatory nor directory, either mandatory or directory. What should be the correct answer? Filing the list of witnesses by the complainant before issuance of summon or warrant to the accused under section 204 of CrPC is mandatory, directory, neither mandatory nor directory, either A or B. So it is directory. Next, if the complainant fails to file the list of witnesses before the issue of summons or warrant to the accused, the same cannot be filed thereafter. The same can be filed at any time thereafter without the permission of the court. The same can be filed at any time only with the permission of the court. Option D, either A or B. If the complainant fails to file the list of witnesses before issuance of summon or warrant to the accused, the same cannot be filed thereafter. The same can be filed at any time thereafter without the permission of the court. Option C, the same can be filed by at any time only after the permission of the court. Option D, either A or B. What should be the correct answer? The same can be filed at any time only after the permission of the court. Next, special summons under section 206 of CrPC can be issued by the magistrate only, by the court of session only, by the magistrate as well as by the court of session. Option D, by the high court. What should be the correct answer? The special summons can be issued under section 206 of CrPC by the magistrate only, by the court of session, by the magistrate as well as by the court of session, by the high court. What should be the correct answer? Question number 34. स्पेशल समन कौन इशू कर सकता है? तो स्पेशल समन कैन बी इशूड ओनली बाय द मैजिस्ट्रेट. Next, a case can be committed to the court of session by a magistrate under section 209 of CrPC, under section 323 of CrPC, under section 324 of CrPC, and option D is both A and B of the above. So remember one thing, before framing of charges, if the magistrate feels that the case has to be committed to the court of session, that committal of case can be done under 209 of CrPC. And after framing of charges, if the magistrate realize the same, then it has to be done under section 323. So both of these sections empowers the magistrate to transfer a case to the court of session or to commit a case to the court of session. Okay? So its correct answer shall be option D, both A and B of the above. Very good, Ritesh. Its correct answer shall be option A for previous question. Next question. Under section 209 of CrPC, under section 209 of CrPC, a case can be committed to the court of session. Under section 209 of CrPC, a case can be committed to the court of session only if the offence is exclusively triable by court of session. Option B, if the magistrate thinks that the case ought to be tried by court of session. Option C, both A and B, and option D, neither A nor B. What should be the correct answer? So its correct answer shall be option A, that is, if the offence is exclusively triable by court of session. under section 323 of CrPC provides for committal of the case to the court of session, which discloses commission of offences exclusively triable by court of session, which the magistrate thinks ought to be tried by court of session, both A and B, only A and not B. Under section 323 of CrPC provides for the committal of case to the court of session when it discloses the commission of the offences exclusively triable by the court of session, when the magistrate thinks it ought to be tried by the court of session, both A and B, and only A not B. What should be the correct answer? When the magistrate thinks it ought to be tried by the court of session. So after framing of charges, if the magistrate realizes that the case should be tried or ought to be tried by the court of session, then in that case, such case can be committed to the court of session. Under section 210 of CrPC provides for stay of the police investigation, stay of the proceeding in complaint case, both A and B, neither A nor B. अब देखिए, अगर किसी एक केस में कंप्लेंट भी होती है और उसी केस में आपका जो मैजिस्ट्रेट साहब हैं, ठीक है, वो कंप्लेंट के थ्रू भी प्रोसीडिंग चला रहे हैं और पुलिस भी इन्वेस्टिगेट कर रही है, तो कौन सी प्रोसीडिंग कौन सी प्रोसेस स्टॉप कर दी जाएगी? ठीक है, सो द करेक्ट आंसर इज stay of proceeding in the complaint case, and it shall be realized that the case has been instituted by the police investigation. Its correct answer shall be option B. Next question. In section 210 of CrPC can be invoked where there is a complaint case and the police is also investigating the matter. Where there is a complaint case and the police is also investigating the matter, where there is a complaint case but no police investigation is in progress, when there is a complaint case and the police has already completed the investigation and filed the final report, option D, all of the above. What should be the correct answer? अगर एक ही केस में सेक्शन 210 कब इंपोज होगा? जब एक ही केस में कंप्लेंट केस भी है और पुलिस भी इन्वेस्टिगेट कर रही है. सेकंड ऑप्शन बोल रहा है कंप्लेंट केस है लेकिन पुलिस इन्वेस्टिगेशन प्रोग्रेस में नहीं है. ऑप्शन सी बोल रहा है when there is a complainant case and the police has already completed the investigation and filed the final report. Option D, all of the above. What should be the correct answer? बताइए. क्या होना चाहिए इसका करेक्ट आंसर? क्वेश्चन नंबर 39 का जल्दी से बताइए. Its correct answer shall be option A. So when there is a complaint case and the police is also investigating the matter, then it will be considered the case of section 210. Next, question number 40. In case of merger of complaint case with the police report, the procedure to be followed for the trial shall be a complaint case shall be in a case instituted on a police report, shall be a case for both as per the convenience during the trial, shall be the one as directed by the magistrate. What should be the correct answer of this? So its correct answer shall be as a case instituted on the police report and not otherwise. Next question. Before the issuance of process against the accused in a complaint case, the accused has the right to participate in the proceeding. The accused has no right to participate in the proceeding. The accused has the right to watch the proceeding. And option D is both B and C. बिफोर इशू ऑफ प्रोसेस अगेंस्ट द अक्यूज, जब तक अक्यूज के अगेंस्ट प्रोसेस इशू नहीं हो रहा है इन अ कंप्लेंट केस, अक्यूज क्या कर सकता है? प्रोसीडिंग्स में पार्टिसिपेट कर सकता है, हैज नो राइट टू पार्टिसिपेट इन द प्रोसीडिंग, द अक्यूज हैज द राइट टू वॉच द प्रोसीडिंग, बोथ बी एंड सी। क्या होना चाहिए? सो इट्स करेक्ट आंसर शैल बी बोथ बी एंड सी, क्योंकि जब तक कंप्लेंट केस है और अक्यूज के अगेंस्ट अभी तक प्रोसेस इशू नहीं हुआ है तो ही कैन मेयरली वॉच द प्रोसीडिंग एंड कैन नॉट पार्टिसिपेट इन द प्रोसीडिंग। Next question, question number 42. Order of issuance of process against the accused in a complaint case under section 204 of CrPC by the magistrate can be reviewed by the court issuing the summons, cannot be reviewed by the magistrate under section under the CrPC. The magistrate has no power to review the order. Option C, can only be revised by the court of session or high court. Option D, both B and C are correct. Where the court has issued a particular process against the accused in a complaint case under section 204 of CrPC, then the magistrate has which of the following power? Magistrate can review the court issuing the summons. That is the correct answer. So its correct answer shall be option A. Next, after dismissal of complaint under section 203 of CrPC, a fresh similar complaint on the same facts is not banned but will be only entertained in exceptional circumstances, is not banned but will be entertained in all circumstances, and option D, either A or C. What should be correct answer? अगर सेम ही केस में कंप्लेंट होती है और उसको डिसमिस कर दिया जाता है, फिर दोबारा से सेम सब्जेक्ट मैटर पे कंप्लेंट होती है सेम फैक्ट को लेके, तो वो कंप्लेंट बैन नहीं होगी बट इट विल बी डेल्ट इन एक्सेप्शनल सर्कमस्टेंसेस, नॉट बैंड एंड विल डेल्ट इन ऑल द रेगुलर सर्कमस्टेंसेस, and either A or C. So its correct answer is not banned but it will be dealt only in exceptional circumstances. Last question for the day is, committal proceeding under section 209 of CrPC are the nature of aid in investigation, inquiry, trial, either inquiry or trial. What should be the correct answer? Committal proceeding जो होती है under section 209 of CrPC वो क्या है? एड इन इन्वेस्टिगेशन है, इंक्वायरी है, ट्रायल है, आइदर इंक्वायरी और ट्रायल. व्हाट शुड बी द करेक्ट आंसर? Its correct answer is aid in investigation. Right? So that is it for the day. I hope you people have enjoyed today's class. If you find it informative, if you found that you were able to learn something new and innovative by attending this class, don't forget to like the video, subscribe to our channel, and see you people in the next video.